Yeah. Hello, everyone. Sorry for the delay. To be honest, there were some technical issues, and I was here waiting since 6:30 p.m. I guess. I hope you're all doing good and confident enough. I guess. Please let me in the chat box if you are there. Please message me hi or maybe good evening. Anything works. Just to let me know that okay, you are there in front of me, and I'm not facing zombies. So you can just message me once that okay, you are there, so that we can start the session. There are so many things that I need to discuss with you, so many inputs that I'm wanting to give it to you, and all of that will start within maybe 1 minute. So just let me know your presence, make me feel your presence, and we shall start within a minute for sure. Okay, so I have MRP. Good evening, sir. Priya, good evening. Abhijit, hello, sir. Priya, good evening. Shri, good evening. Dhanyashri, good evening. Sindhu, good evening. Redmi, okay, good evening. I can see approximately 20 over here right now on Zoom. Shivani, good evening. Many of them already on YouTube also. Okay. Sujit, good evening. Okay, if we are not wasting any further time, we are already delayed by 22 minutes because of some technical issues. So we are not waiting any further time and we are starting and coming directly to the topic. Okay. Sujit and Sanjay, good evening. So we basically have two agendas for today. Okay, two agendas. The first one, obviously, which you know already, which is discussion with regards to the mock paper. Okay, and the second one, which is to me more important, which exactly is giving you some last moment tips for your law exams, because I think we know it already. There are only two scary subjects. One is obviously law, and one is maths. I guess maths has been taken care of already by Sheikh sir, and law I'll take care of. So before starting to solve this mock paper of yours, let me give you a few inputs, few important ones, and then we'll start. Okay, I'll just share my screen. If they can just enable me to share my screen, just a second. Please make me host. Okay, I can share the screen now. Here we go. Okay, this is one of the agendas that we have for today, that is solving this wonderful mock test paper, which has, the questions handpicked, especially important ones for the exam, wonderfully designed. And the other one is the inputs that I'm going to give you. This is one of the many inputs that I'll give you in next 1 or 1.5 hours. Starting with, the paper presentation. This is your case study question, the way that you need to answer the case study questions. This is something you might not be knowing, and this is something you must know before you happen to give your final exams. So please listen to me carefully. All this is super important because we are here 10 days before the exams. So there's no irrelevant talks, only relevant talks. So the first thing that I can see over here is, sir, in case there is a case study question that is asked in the exam, I will divide my answer in 3 paragraphs. You can see the heading as well. The first paragraph, which is the most important one, relevant provision. You need to give this heading, relevant provision. The second paragraph would be fact of the case. And the third one would be conclusion. So the first learning is you will divide your case study answer in 3 parts. Now, if I happen to come back to the first part, which is relevant provision, here you will basically state all the section numbers that are attracted, the case laws, if any, they're attracted, and obviously the main law. Everything will be basically over here in this paragraph, which is relevant provision. So we just happen to look at my example that I've given, section number 33 of Partnership Act. I've written section number, I've written act name, the year, and the whole law. After that, I've written second paragraph, which happens to be facts of the case. Would you believe you just need to do the summary of the question that is there in the exam paper? Just do the summary of the same and write as it is over here in fact of the case. And for this, you happen to get 1 mark. Just imagine. All you need to do is write summary of the question that has been asked in the paper. Write the summary of it, means in short. precise writing sort of. And for that, you happen to get 1 mark because you are telling the paper checker that, see, I have understood the question that what has been asked from me. So you get 1 mark for the same. So you just cannot ignore this 1 mark. And finally, we happen to be on the conclusion. That is the main answer of whatever has been the question. And as you can see, I've underlined the main points that are there in my answer. So I've underlined the conclusion can be expelled. I have underlined the main provisions, the main words, contract, majority, good faith, then notice, reasonable opportunity of being heard, and interest of the firm. So all the main points I have underlined, and I've divided my answer in these 3 parts. One more thing, what students happen to do is they write it like this, something which you will not do. Question number 3. No, you cannot do it like this way. This left hand side, the margin is there for the paper checker to allot you marks. You just cannot write anything on the left hand side of the margin. In case you happen to do so, you will basically irritate the paper checker. And once you happen to irritate the paper checker, he will start to cut your marks. So all I am requesting you from my side is we will not use the left hand side of the margin. You will conspicuously, clearly write at the center of the page the answer that you're about to start. So see how clearly I've written answer number 3A. It should be very clear to the paper checker that what you have answered. He should not be finding, okay, which answer is this? Write it very clearly. So this is basically the first learning that I wanted to give you. And the basic mistake is done at this level only. So all those in the meeting, all 19 of them, 20 of them, can you please let me know if you are okay with this? Can you just give me a thumbs up, or maybe if you have understood this or not, or maybe felt this to be good enough? Can you please let me? You can just message me. It's fine.
Sir, in Article 17, to mention the
I'll
duties
also
of
take
Prime
your personal question, obviously, as well.
Mention the duties of Prime Minister. A Prime Minister decides the rank of its
So I
ministers
basically have a
and
message as of now. I'll mute the others. Just a second. Okay. I have a message from Priya. Okay. Others that are watching, let me know if you are clear with this. I will obviously take up your doubts, but first I want you to let me know if you are clear with this. I have message from Sindhu. I have message from MRP. I have message from Dhanyashri. Clear, sir. Okay, sir. Okay, sir. Others, I hope I'm clear with whatever I'm talking with you right now. Let me know so I can jump to my next point. Okay, I have a message from Priya also. Okay, Shivani also. Okay, many of them. Let's move to the next topic. So what if the question is a theory question? In that case, how exactly do we need to answer? All you need to take care of is you don't happen to make lengthy paragraphs. Whatever the theory question is, in case you are answering the theory question, don't make lengthy paragraphs. Either use bullet points or use small paragraphs. In case you happen to make big paragraphs, the paper checker is not going to, burn his eyes to find your main answer. He will love it if it is in bullet form or if it is in short paragraphs. So in case of theory question, please make sure that you don't happen to write big paragraphs. Secondly, I guess we know the paper pattern already by now. That question number 1 is compulsory, and from the remaining 5 questions, you need to attend any 4 of them. I guess we know this already right now. What I'm telling you is you need to start from your best answer. Suppose you feel like that question number 3 is my best question, which I can solve very well, and I know all the provision of question number 3. In that case, please start your paper from question number 3. You can start from question number 3, then you can jump to question number 5, then come to question number 2, then 1, then any sequence is allowed. What is not allowed is you cannot do it like this, that you are attempting. Let's say question number 3, okay? So you're writing question number 3, A. Then you're writing question number 4, C. No, this is not allowed. If you happen to start with question number 3, you need to complete the whole of question number 3. So you can obviously change the sequence of your answers, but you cannot change the internal sequence of the answer. So in case you happen to start with question number 3, finish question 3, ABC, then jump to question number maybe 2, ABC. So please make sure you happen to take care of this as well. So this is basically the second and third learning that I wanted to give you. So the first one was how to present a case study question. Point number 2 was basically how exactly you happen to write a theory question. And obviously the last one, which I just told you, that you can write nothing on the left hand side of the margin. And also this one, that you can start with the best possible answer, and the sequence can be of your choice. But just don't do this haywire of jumping to question number 3, then 4, then 1. Don't do it like this. We started a question, complete, then move to the next one. Okay. Coming back to your mock test paper, I have more inputs to give, but first let's discuss this also. Very good paper, hand-picked questions and wonderful questions. Let's start. I'm on basically question number 1. Let's read it meticulously and let's see what we can get from the question. Ashish was running a business of artificial jewelry since long. I'll mark artificial jewelry. Okay. He sold his business to Naman and promises not to carry on the business of artificial jewelry and real diamond jewelry in that area for a period of next 1 year. What I can judge as of now is this is something similar to agreement in rescission of trade. And this seems as of now sensible because this is reasonable in that area for a period of next 1 year. This seems reasonable, and we have studied that agreement of rescission of trade is allowed if it is reasonable. Okay, next. After 2 months, Ashish opened a showroom for real diamond jewelry. Okay, so prima facie it was artificial jewelry, and we have now opened real diamond jewelry. What I can see is different business. Okay. Naman filed a suit against Ashish for closing the business of real diamond jewelry business as it was against the agreement. Whether Ashish is liable to close his business for real diamond jewelry following the provision of Contract Act? No, sir. The new business and the previous business are not connected at all. The previous one was artificial jewelry and the newer one is real diamond jewelry. It is altogether a different business, different sector, and altogether a different thing. So whatever restriction is there is obviously not applicable because the business is different. Had it been artificial jewelry, then it can be restrained. But this is real diamond jewelry. Let's see the answers. Here we are. Like we said, we had to be going to section number 27 of the Act. Let's see what it says. According to section 27 of the Act, an agreement by which any person is restrained from exercising a lawful profession, trade or business of any kind is to that extent void. But this will be subject to following exceptions. See, we are here, exceptions. Namely, where a person sells the goodwill of a business and agrees with the buyer to refrain from carrying on a similar business within specified local limits, so long as the buyer or his successor in interest carries on a like business. In this case, it was not a like business. It was a different business altogether. Let's come to the conclusion. See, this is fact of the case, which I was telling you 5 minutes back, that you need to repeat the question. For this, you happen to get 1 mark. Just imagine. You just need to repeat the question, summarize the question, and for that, you happen to get 1 mark. You just cannot miss out on this opportunity of fetching 1 mark for free. Let's come to the conclusion. As exception to section 27 is applicable to similar business only, agreement between Naman and Ashish will not be applicable on business of real diamond jewelry. Hence, Ashish can continue his business of real diamond jewelry. So I think you can see the sequence now. There are 3 parts. This is basically the whole provision, which I was showing you to be like this relevant provision. See this paragraph. It was this relevant provision. Then I could see fact of the case and finally conclusion. You can see that it has been answered similarly. So very good question. Fantabulous question. Let's come to the next one. I can see this to be of Companies Act. Let's see. G Private Limited is incorporated as unlimited company. What should strike to my mind is section 2 clause 92 is unlimited company of Companies Act. Having share capital of rupees 10 lakhs, one of his creditors, Mr. S, filed a suit against a shareholder, Mr. Innocent, for recovery of his debt against the G Private Limited. Mr. Innocent has given his plea in the court that he is not liable as he is just a shareholder. Explain whether Mr. S will be successful in recovering his dues from Mr. Innocent I. See, what you prima facie needs to recall is, in unlimited company, the liability of the member is unlimited. It can even extend to your personal assets as well. Even your personal assets, personal car, house, everything at stake. But what you also need to know is, sir, firstly, we happen to sell all the assets of the company. And in case it is a shortfall, then liquidator will call us and tell us that, okay, you need to pay this much, and then I will have to pay. So what needs to be known is I need to wait for the order of liquidator. I hope we are aware what is liquidator. You must have read it in Doctrine of Indo Management, Royal British Bank versus Turquant, where Turquant was the liquidator, who basically, does all the payment of dues, selling of assets and everything. So I will have to wait for the order of liquidator, and according to the directions of liquidator, I will basically pay off what has been asked for. So you cannot directly ask the shareholder that, okay, give me all the money. No, you cannot do so directly. Wait for the liquidator's order. So merely 4-mark question, a very easy question, I would say. Let's see what it says. Okay, I can see the section as well. 2 clause 92. Here we are. There can be doubts in your minds that, sir, do we need to quote sections? I would say yes, 100% yes. What you need to know is, see, you are giving professional exams. This is not a BCom paper that you will write, anything. You need to properly write section numbers. In case, let's assume you are not well versed with section numbers as of now, it is okay. I would give you a list of important section numbers. Just remind me. I will give in a list of important sections, maybe 10, 15 each in each chapter. That much you need to do. Okay. So I'll send it to you for sure. Let's come to the question now. So he basically says the whole of section 2 clause 92 is here in front of me that I can see. Let's come to the conclusion. Mr. I is liable up to his share capital. His unlimited liability will arise when official liquidator calls the members for their contribution towards the liabilities and debts of the company at the time of winding up of the company. So in case the company is winding up, in case we are closing down the company, liquidator will be appointed and he will decide who needs to bring in how much money. So I'll wait for him, and the creditor cannot ask me directly to pay all the sum. Okay, a very easy question. Second one for 3 marks. A company registered under section 8, what you can recall is company formed for charitable objects, has been consistently making profits for the past 5 years. Okay, after a major change in the management structure, few members contended that they are entitled to receive dividends. No, sir, no, not at any cost. A section 8 company is prohibited from declaring any dividend. Not allowed. So the question is, can the company distribute dividend? Of course, no. 100% no. See how much confusing the question is getting into. If yes, what is the maximum amount of dividend? It is only for confusing you. The answer is, sir, dividend cannot be distributed. So there is no point asking the maximum percentage of dividend. It is irrelevant. Let's come to the second half. Also, to discuss along with other regular matters, the company held a general meeting by giving 14 days notice. Is this valid? Answer is yes, it is valid. Sir, a normal company, a regular company, which is not section 8 company, needs to give a notice 21 days in advance. But as far as section 8 company is concerned, even 14 days prior notice is 100% okay. It is allowed. So I would say the first half of the answer is obviously no, it is prohibited to pay dividend. And the second half is yes, it can call general meeting by giving a prior 14 days notice instead of 21 days. Please message me, let me know, are we clear with whole of question number 1? In case you have any doubt, I will listen to you. I will clear the whole doubt. But you need to let me know that yes, you are clear with whole of question number 1. Please message me, or maybe a thumbs up will do. I'll wait. Are we clear with the whole of question number 1? Okay, I have a message from Priya who says yes. Dhaneshi says clear, sir. Okay. Another Priya says okay. Okay, I have 1 thumbs up. 4-5 messages already. Shivani says clear, sir. Farzana says yes, sir. Okay, thank you. Am I waiting for anyone else? Husna and MRP gives me a thumbs up. Okay, okay. 7, 8, 9 messages already. I'll assume the remaining are able to understand. Let's move further. Very good questions to follow. The conclusions, I'll mark it for you. Prohibited. We discussed this already. And the second one, allowed. The next one, C. Define partnership. You will directly quote section number 4. I hope we are knowing this section number 4, which basically happens to define the partnership. What next? And name the essential elements for the existence of partnership as per the Partnership Act. I hope you can recall there were 5 elements. The first one was 2 or more persons. The next one was there has to be a business. Next, there has to be an agreement between the partners. Next, agreement should be to share the profits and not the losses. And the last one, the most important, business carried on by all or any of them acting for all. Basically, mutual agency. Let's say you cannot recall all this. I'll give you a trick to remember the same. It is two Baba, in which two is two or more persons. B is some business. A is agreement. Next, B is business carried on by all or any of them acting for all. And agreement should be basically to share the profits. Sharing of losses is not essential. Sharing of profits is essential. And this also basically 5 marks. So you happen to write the definition, obviously, section number 4. And then you happen to write, obviously, the elements. Easy question again, I would say, but important one. Here we go. Two Baba. Okay. Easier way to remember the same. The next one. Okay, question number 2 seems to be a good question. Let's see what it says. Mr. F sold some goods to Mr. Z on a certain price by issue of an invoice, but payment in respect of the same was not received on that day. Okay. The goods were packed. That means they were in deliverable state. The goods were packed means they were in deliverable state. The goods were packed and lying in the godown of Mr. F. The goods were inspected by X's agent and were found to be in order. Okay. Later on, the dues of the goods were settled in cash. Just after receiving cash, Mr. F asked Mr. Z that goods should be taken away from his godown to enable him to store other goods. Okay, so this seems to be a very important line now. I'll just mark it. Mr. F asked Mr. Z should take goods should be taken away from his godown to enable him to store other goods purchased by him. After one day, since Mr. Z did not take the delivery of the goods, Mr. F kept the goods out of his godown because there was no space and he was wanting to keep other goods. So he kept the goods of Mr. Z out of the godown in an open space. Then there were the rains were there and some goods were damaged. The question is, referring to the provisions of Sales of Goods Act, analyze the above situation and decide who will be held responsible for the above damage. Second half, let's read it later. I want the answer of the first half. I think we can answer this way. Sir, F had already told Mr. Z that please take the goods away. I need to store the other goods. And even after, listening to this, the goods were not taken away. So in that case, obviously the fault is of Mr. Z that even after informing, he did not take away the goods. Let's come to the second half. Will your answer be different if the dues were not settled in cash and still pending? In that case, we'll go to lien and all those things. Let's come to the answer. This is the main provision. According to section number 44 of the Sales of Goods Act, when the seller is ready and willing to deliver the goods and request the buyer to take the delivery, and the buyer does not within a reasonable time, very important, after such request take delivery of the goods, he is liable to the seller for any loss occasioned by his neglect or refusal to take delivery, and also for a reasonable charge for the care and custody of the goods. Let's come to the conclusion. In the given case, Mr. F has already intimated Mr. Z that he wanted to store some other goods, and thus Mr. Z should take the delivery of the goods kept in the godown of Mr. G. The loss of the goods damage should be borne by Mr. Z because he was informed already. I have a message. Let's read the message once. Okay, the Priya had given me the answers. Priya, thank you. The answer was right. Let's come to the second half. This was an easier part, I guess. If the price of the goods would not have settled in cash and some amount would have been pending, then Mr. F will be treated as unpaid seller. And once you're an unpaid seller and the goods are there with you only, you can obviously exercise lien. The second half was very easy. The first half was a good question. Second half was too easy. I can also sue him for the price. And in case there was stoppage in transit, I can do that also. Everything can be done if I'm an unpaid seller. Very important question for exam B. Very, very important. I personally feel that this question will be there in your exams. That is, explain the doctrine of ultra vires under the Companies Act. What are the consequences of ultra vires act of the company? 7 marks. So basically, you need to definitely quote the case law. I think the case laws is something that you remembered and studied, and the case law that we attracted in doctrine of ultra vires obviously is Ashbury Railway Carriage and Iron Company Limited versus Ritchie. I think we know this already. And we obviously need to explain a bit of doctrine of ultra vires. You definitely write in your paper beyond power. If beyond power is missing in your answer, then your answer is worthless. You need to start it like this. Doctrine of ultra vires is basically when the acts are done which are beyond the object clause of the MOA or beyond the Companies Act. And again, obviously, you need to state the case law. What is more important is this part. What are the consequences of ultra vires act? I hope you remember there are 4 consequences. The first one is, in case an act is ultra vires, it will be regarded as null and void, zero, as if nothing happened. So if an act is ultra vires, it will be regarded as null and void. Second one, if an act is ultra vires the MOA or the Companies Act, it cannot be ratified even by unanimous consent of the shareholder. Even if 100% shareholder agree that, okay, let's allow this. No, it cannot be allowed. Even the unanimous consent of shareholder cannot ratify the ultra vires act. The third one, sir, if the act is ultra vires the directors but intra vires the company, it can be ratified. And the last one, if an act is ultra vires the articles can be altered and can be ratified by passing special resolution. So these consequences are very important for your exams. This is what I'm telling you right now, 10 days before the exam, that please do this very carefully. The consequences, I'll repeat them for you. The first one, sir, if an act is ultra vires the object clause of MOA, it is to be regarded as null and void, zero. Second one, an act which is ultra vires cannot be ratified by unanimous consent of the shareholders. Number third, if an act is ultra vires the directors but intra vires within the power of the company, it can be ratified. And the last one, obviously the easiest one, if an act is ultra vires the articles, it can be ratified by passing the special resolution. So very important question. I hope we are clear with this one also. Obviously, you need not write such a huge answer. All you need to do is make small paragraphs and write in bullet points. Simple. Next one. A, B, C, D are partners in Messrs A, B, C, D and Company, a partnership firm which deals in trading of washing machines of various brands. Okay. Due to conflict of views between the partners, A and B decided to leave the partnership firm and started competitive business on 31st July in the name of Messrs A, B and Company. Okay. Meanwhile, C and D have continued using the property. Okay, the main point of the question is this. They have continued using the property in the name of Messrs A, B, C, D and Company, in which A and B also has a share. This was the main point. Let's come to the question now. Based on the above facts, explain in detail the rights of outgoing partners as per the Partnership Act and comment on the following. The first one, right of A and B to start a competitive business. And the second one, right of A and B regarding their share in property of Messrs A, B, C, D and Company. I'll first discuss this one, the important one. Sir, in case the settlement of accounts has not been done, in case your money is still lying in the partnership firm and you are not being paid for, in that case, I guess we know this already, that you will continue to receive the share in the profits, the stake of yours. You will continue to receive the profit sharing ratio of yours, or you can get 6% interest on the amount that is there inside the partnership firm of yours. It is your choice. You can either continue to receive the share of the profits that was there of yours, or you can receive 6% interest on your amount, on your capital that is there still inside the partnership firm. And it is your choice to take any of these. This is my answer for the second half. Let's come to the first half, which says rights of A and B to start a competing business. Obviously, you can start the competing business. Obviously, what needs to be taken care of is 3 things. You cannot use the firm name, okay, the previous firm name. You cannot still portray to the others that you are still the partners of in the old firm, and you cannot solicit the customers of the previous firm. If all these things are taken care of, you can obviously start a competing business. It is 100% allowed. Let's see the answers. Here we are. See all the conditions that I just discussed, all 3 of them. You cannot do these things. Use the firm name, represent to be still the partner over there, and solicit the customers of the previous firm. You cannot do so. In that case, if you haven't done all these 3 things, you can obviously start the new business. And the next one, I'll just mark the main points. Here we are. entitled the option of himself or his representative to such share in the profits made since he ceased to be a partner as may be attributable to the use of his share or to the interest at the rate of 6% per annum on the amount of shares in the property of the firm. Very simple and obviously very important. This was not there in the previous attempt. So yes, it is an important question for your attempt. Question number 3. L and P are partners in Messrs. Lee P and Company. Firm is doing business of trading plastic bottles. Okay. L is authorized to sell the stock of plastic bottles. Okay, we have given L a duty. It is decided between them that L should sell plastic bottles at a minimum price, which they have decided. And if L sells at a price less than the minimum price, he should take the permission of P. Okay, so we have given L a permission to sell the water bottle. And if he wants to sell at a lower price than the specified, he needs to take permission from P. Okay. Due to sudden change in government policy, very important line. Due to sudden change in government policy, the price of the plastic bottles were continuously declining. In a blink of a second, it should be clear in your mind, okay, sir, this is a case of emergency. Partner's authority in case of an emergency. He can do every such act which is there to protect the partnership firm, which a person of ordinary prudence in a similar circumstances would have done. He can do all such acts, and his act will bind the firm. Let's see. To save the loss of the firm, L sold the stock at a lower price, and then there were a case on the P. Answer. Coming to the conclusion directly, obviously, let's not waste time. As the act of L was in favor of the firm, he was not liable to bear the loss. Sir, my authority in case of an emergency. I have done a thing which a prudent man would do in the similar case. I have done the same thing, and hence I am not liable. A very good question. Next one, marking important, very important rather, which is 2 clause 85, which is small company. Let me see the answers as well. So what is the maximum length of case study questions we need to present? MRP, I will give you a chance after 5 minutes to interact one-to-one. Don't worry. Just wait for 5 minutes. Let me finish this question and we'll interact one-to-one. Okay? Don't worry. Yes, Dhanashri, very good. Dhanashri, very good. Okay, back to this. The question is of small company. What you need to recall is the definition of small company. In any circumstances, whatever the topic is, you need to give a definition if there is definition of that particular section. So what I can right now see is it is section 2 clause 85 small company. I need to give the definition which goes like this. Sir, a small company is a company which is other than public company. Then the 2 points. The paid up share capital of which is 4 crores or less. And the turn of which is 40 crores or less. This is what the definition is. And you also need to state 10 crores and 100 crores. Now let's see the question. So first you'll give the definition. Okay. RQS Private Limited is a company registered under Companies Act with a paid up share capital of 5 crores. No, it is exceeding 4 crores, not allowed. And turnover of 35 crores. See, this is within limit. This part of 35 crores is obviously within limit. But this is not within limit. And what the definition says, it has and in between. Means both the criteria need to be satisfied. The paid up share capital of which does not exceed 4 crore rupees and turnover of which does not exceed 40 crore rupees. So both the conditions need to be satisfied, and because one of them is not being satisfied, it is not a small company. Simple. So question itself says, explain the meaning of small company and examine the following in accordance with the law. Okay. Whether the RQS Private Limited can avail the share of small company? Definitely no. Definitely no. What will be your answer if the turnover of the company is 45 crores? How does it make a difference? It is anyway exceeding the limits. Let's see the answers. Here we are. See, the first thing I can see is the definition. You need to write the definition. Whatever the question is, you need to write the definition. And then the answers. Cannot. Very simple. Yes, what I'll do right now is in the at half of the session of paper solving, I'll give you a chance to interact with me one-to-one and ask me the doubts. Obviously, just give me a second. Okay, I have unmuted you. You can ask me questions one by one. Please raise your hands. I'll give you a chance. Please raise your hand. I'll give you a chance to speak and interact with me one-to-one. Do we have anyone? You can raise your hand or just type in the chat box that you have something to ask, and I'll give you the chance. Do we have anyone? Okay, we have one in chat box which says MRP. MRP, you can speak. It is okay. Can you? I've unmuted you. You can speak, sir. Sir, what is the maximum length of? Yeah, listening.
I have a doubt. In last attempt, I presented around 3 to 4 pages each of the case studies, but the marks I got I RTI is little more difference. So, what is the precise answer we should give for how many pages?
Okay, got your question very well. See, basically, again, I'll tell you the same thing. This is not BCom. It is not the criteria that you happen to write more and more pages and you happen to get more and more marks. What we are basically expecting from you is answer to the point. Now, to the point does not mean that it will be very crisp and short. Like I said, if it is a case study questions, I'll divide it into 3 parts, and I'll try that if it is a 5-mark question or if it is a 6-mark question, at least 1 page is getting filled. That much content you obviously have because you're dividing your answer in 3 parts. So anyway, 1 page is there to be on the minimum side, and at the max, if it is a 7-mark question, which is the maximum they can ask 7 marks. In that case, obviously we expect 1.5 pages, and the content is there because then only it can be worth 7 marks. Yes, MRP, I hope we are clear.
So, in last attempt, they asked one question in OPC, 1% company.
Yeah, there are 12 points. There are 12 points, and it was a 7-mark question. It was, I think, question number 1C, if I'm not wrong. And you were supposed to write all the 12 points. If I happen to recall, you need to write only 1% member. Then you happen to obviously write minimum bid of share capital, no limit prescribed. Then you have to write nominee has to be there. Prior written consent of the nominee. Nominee can be removed. Nominee can withdraw his consent. This remove and withdrawal will not be considered as alteration of the memorandum. He needs to be a national person who is a citizen of India, whether or not resident. Then you need to write a person can be member in one OPC and nominee other OPC. Minor cannot be a part of the OPC. You cannot get converted or incorporated in Section 8 company and cannot carry out non-banking financial investment activities. All these 12 points, which I just spoke in the sequence of the book, you were supposed to write. What did you do?
Yeah, actually, I written the provisions of the OPC and I written the provisions of the company as well as the private company, and I written around 10 points in the salient features of the OPC, and I got around just 6 marks out of 7. The
6 out of 7.
Yes.
To me, 6 out of 7 is a very good score. But what I'm more concerned right now is, were you able to finish your paper?
Yes, I have finished.
Then in that case, there is not an issue. But if I were at your place, to me, it would have taken me maximum 1.5 pages. Because 12 points, even if I happen to leave 1 line each after each point, even in that case, there were 1.5 pages, not more than that. And anything more than that is outrightly irrelevant. A possibility of you happening to, miss the paper of writing it off 100 marks.
Yes, thank you.
Okay, any other can definitely ask me freely, whatever is there in your mind with respect to the law subject. Anyone else, or else I'll continue with my solving. Do we have anyone else? Any doubts? Anything which needs to be asked? Any problem which is there? I'll wait for 30 seconds. Do we have any? Abhijit, Apurva, Dhaneshri, Fahad, Husna, MRV, Priya, one more Priya, Redmi, Sanidhya, Shivani, anything do we have in the mind to be asked? No, I cannot see anything. Moving further then, moving ahead. The next one, C. An anticipatory, unit number 5, Indian Contract Act, unit number 5. An anticipatory breach of contract. Okay, I have a message right now. No, sir. Okay, take it. An anticipatory breach of contract is a breach of contract occurring before the time fixed for the performance has arrived. Definitely correct. Discuss stating also the effect of anticipatory breach of contract. See, you have 2 options. You can outrightly sue the party on the very set day at the time you felt that this person will default on the due date. If you happen to feel so 10 days prior, you can directly sue the person. Or the second thing you can do is you can just wait till the day of performance and then sue the other party. But in that case, you are keeping the contract open for the benefit of both of you. In case there is any supervening impossibility, then the other party will take benefit of the same. That I was going to perform, it was just because of the impossibility that I could not perform. Both the points you basically need to write. Unit number 5, Indian Contract Act. Easy question, I would say. Here we are. See both the points. Here I can see both the points. Next one. Explain whether the agency, a very good question, I would say. Very, very, very good question. This is basically your agency chapter. The last page of your chapter. This question belongs from there. Last page of your chapter. Okay. Explain whether the agency be terminated in the following cases under the provision of Contract Act. P gives authority to Q to sell P's land and to pay himself. As soon as I read pay himself, I can only strike, the only thing that strikes in my mind is, sir, here the agent is personally interested. Means there is something in the contract which will benefit me. In this case, the agency is irrevocable. The agency is irrevocable. Even in any circumstances, it cannot be revoked. It just cannot be revoked. The second one. A appoints Q as P's agent to sell P's land. Okay. Q under the authority of P appoints R as an agent of Q. Okay, so I think this is question of sub-agent. Okay, works. Next. Afterwards, P revokes the authority of Q but not R. So if I happen to draw the diagram, it goes something like this. A appoints Q as P's agent to sell P's land. Okay. A, Q, and P basically have 3 people. A, Q, and P. So A appoints Q as P's agent. Okay. To sell P's land. Okay, sell P's land under the authority of P. Appoints R as agent of Q. Okay. Afterwards, P revokes the authority of Q. P revokes the authority of Q, but not R. I think we know it already. If the authority of agent is revoked, the authority of sub-agent is automatically revoked. Last paragraph of chapter Contract Act, unit number 9, last page, last paragraph is this section only. That in case the authority of agent is revoked, the authority of sub-agent is automatically revoked. Here we are. The first one, we didn't see the answer. Here we go. P cannot revoke the authority, nor it can be terminated by his insanity. Why? Because the agent was personally interested. Section 202, very important. Easy question. What are negotiation instruments? A very important question again, I would say, for your attempt. A very important question. Explain the essential features. So we'll define negotiation instrument basically and write down the features. It has to be in writing. It has to be signed. It can be transferred in number of time before its maturity. It can either be unconditional order or can be unconditional promise. It must be delivered. All those points needs to be there in your answer. Easy question, theory question. What is the significance of Supreme Court and High Court of the Indian Judiciary? This is again basically chapter number 1, Indian Equity Framework, last page, where the hierarchy of the courts has been given. So you'll write basically about Supreme Court. 2 main points are there. Okay. The apex court in India, and the second one was basically constituted on 26th of January 1950. The 2 main points. Then you'll write that initially there were 7 members in the bench. Now they have increased because the workload is increased. All these points you'll write. And a writ petition can be filed. The main points in this Supreme Court paragraph. With respect to High Court, you will write, sir, High Court is the apex authority in the state. There are 25 High Courts in each state and union territory, and 6 states share the same High Court. And it can take the appeals with regards to appellant, original, and advisory. This much you need to write. Here we are. Okay. Next one, a very good question. LM sold 500 bags of wheat to No. Each bag contains 50 kilograms of wheat. Okay. LM sent 450 bags by road transport and No himself took remaining 50 bags. Okay. Right now I cannot feel any provision to be attracted. Before No received delivery of 450 bags sent by road transport, he becomes bankrupt. Okay. As soon as I see he becomes bankrupt and as soon as I see Sales of Goods Act, the only thing that strikes in my mind is stoppage in transit. That is the only thing that clicks. Let's see the question further. LM being still unpaid stops the bags in transit. The official receiver on No's insolvency claims the bag. Decide the case with reference to the position of sales of goods. Like, see, you need to see all the conditions. The seller must be unpaid. The goods must have been parted from the possession of the seller. They must be in transit. The buyer should be insolvent, and it has to be as per provision of the act. If all these cases are being satisfied, I can definitely exercise my right of stoppage in transit. A very easy question, worth 3 marks, of course, because it was an easy question. I'll come to the answer directly. Can stop the goods in transit. Okay. The second part. L agrees to sell certain goods to M on a certain date on 10 days credit. The period of 10 days expired and the goods were still in possession of L. M has also not paid the price of the goods. M becomes insolvent. Okay, lien. The goods are already with me and I unpaid seller because he is not going to pay me. Obviously, I can exercise lien. A very straightforward question, I would say. Lien, right of lien. Very straightforward question. B. In provision of Contract Act, answer the following. Mr. D and Mr. P made a contract wherein Mr. D agreed to deliver paper cup manufacturing machine to Mr. P and to receive payment on delivery. Okay, so he'll make me delivery, I will pay him. Reciprocal promise as of now. Next, on the delivery date, Mr. P did not pay the agreed price. Okay, so if he's not paying the price, I will not deliver the goods. So simple it is. Decide whether Mr. D is bound to fulfill. No, obviously not. If he is not fulfilling his promise, why would I fulfill my promise? Definitely not. Second, Mr. H has given loan to Mr. F of 30 lakhs. Mr. F defaulted the loan on due date and the debt became time barred. Time barred debt is unenforceable. Next, after time barred debt, Mr. F agreed to settle the full amount to Mr. H. Whether acceptance of time barred debt contract is enforceable? Yes, sir. Yes, sir. Yes, sir. Section number 25, your Indian Contract Act, unit number 2, last topic. Section 25. Validity of an agreement even without consideration, and one of the point obviously is time barred debt. If the other party gives it to me in writing that he is willing to pay even the time barred debt, then I can recover the same. If he has given to me in writing and here it is there, and I can obviously recover the same now. So section number 25, unit number 2, last topic, third point from the top. The next one. P and Q enter into a contract to supply unique item. As soon as I read unique item, all that I can strike in my mind is this is specific performance, because damages will not solve the purpose. Interest will not solve the purpose. The only purpose will be solved when I get what I wanted, because it is something I will not get from any other place, because it is a unique item. So the only thing that strikes in my mind is specific performance. Let's read the question. I may be wrong. Let's read it fully. P and Q entered into a contract to supply unique item, alternate of which is not available in the market. P refuses. Oh, definitely. P refuses me. That means it is specific performance. Let's see the answers. The other need not be performed. Okay, we discussed this. Section 25, we did discuss this. It has to be in writing. Is it written? He has written in the same writing, in writing. And the last one. Here we go. Specific performance. Very easy. The last one. LLP is an alternative corporate business form that gives the benefits of limited liability of a company and flexibility of partnership. Okay, so you basically need to write 2 paragraphs, one for limited liability and one for flexibility. Under limited liability, you will obviously write, so the liability of the partner is limited only up to his stake in the LLP, and he is not personally liable unless it is a case of fraud. A partner is not personally liable. This is what you write in limited liability. As far as flexibility is concerned, you will obviously write the partners can between themselves decide on themselves the rights and duties of each partner, and there is flexibility in case of LLP, and they can carry out the business as per their own will. So very simple question worth 5 marks. Features basically. Next one. A purchased a mobile from B. He issued a promissory note to B, which was payable on demand, but no specific place for payment was mentioned on it. This is one of the exceptions for presentment. Payable on demand and no specific place of payment was mentioned on it. This is one of the exceptions. Let's see if it is the same question. I don't know. On maturity, B did not. Okay, this is the same question. It says B did not present the promissory note. See, generally what happens is, if you don't happen to present the promissory note on due date, the payer gets discharged. But in this case, what I happen to see is it was payable on demand and no specific place for payment was mentioned on it. So in this case, this falls under the exceptions. Let's see the second question. Jay gave a gift of rupees 21,000 to his sister through a check. Okay, this seems to be section 138, wherein what you need to know is, sir, section 138 obviously has consequences, which is 2, 2, 2, and 2. We remember it like this way. So there are two instances when we happen to say that, okay, the check is bounced. There's this one of check. One obviously is the balance is insufficient, and the other one is stop payment. In case it happens, in that case, you have up to 2 years of imprisonment, up to twice the amount of check as fine, or both. 2, 2, 2, 2. This is how I remember. But what I just read is, sir, this was a gift. If it is a gift, if it is a charity, if it is a donation, this section 138 does not apply. And since it was a gift, this 22222 will not apply. So we're clear with 6A1 and 6A2 very well. Let's see the answers of very, very wonderful questions, both of them. Here we go, exceptions. And would not be discharged. The second one, check was a gift. Provision 138 will not be applicable on J. Fantabulous questions. The last one, when the country guarantee can be revoked. This is Indian Partnership Act, unit number 2, last topic, last page, section number 38, which says in case of any change in the partnership, in case of any change in the firm, all the continuing guarantee automatically gets revoked. The partner comes in, partner goes out, the business changes, anything like that. The continuing guarantee is automatically revoked. Unit number 2, Partnership Act, last page, last paragraph. Last one. What do you mean by goodwill as per the provisions of Partnership Act? Section number 14, you must have read. Sir, partnership property consists of 3 elements. The first one, obviously, the capital contributed by the partners. The number 2, the assets that have been purchased by the partners. And number 3 is obviously goodwill. Now, goodwill is a term which is easy to understand but difficult to explain. This is what your book says. And we happen to write, obviously, the reputation and all those things. It is a part of partnership property, section number 14. There we go. Section 14 is what I can see. And the first one, section 38. Here we are. That's it. Last part. Exceptions of doctrine of cave tempter, I guess very simple. But first, we need to define what is cave tempter. He has not defined, but you will define what exactly is cave tempter. Let the buyer be aware. And then you happen to start to write all the exceptions. Now, since it is 6 marks, maximum that you can write is 6 points. That's it. Only 6 points, which will cover your 1 to 1.5 pages. And the points are same: sample, sold by sample, description, sample as well as description, quality usage, brand name, fraud, all those points. Any 6 of your choice. Any 6 of your choice. That's it. So yes, I would say the paper was very well drafted and very good questions, very important ones for the exam point of view. All I'm wanting to tell you is you need to have a writing practice. You need to know that if you are able to finish your paper in 3 hours or not. So in case you have not given any mock paper, I would suggest you please take out 3 hours and write at least 1 mock test paper before the exams. That will ensure that if you are able to finish the paper in 3 hours or not, which is very important. You might know the concepts, but you might not be able to present the same. You might not be able to express the same. So writing a paper is very important, without which you cannot pass. That is for sure. Important tips I gave you, I think already. What I'm wanting right now for next 5 minutes, last 5 minutes is any doubts from your end with respect to the law subjects, anything, any doubt, any section, any chapter, you can ask me. I'll wait. 5 minutes. You can speak also to save time. Do we have any doubt? Do we have any queries in the mind which needs to be asked? Let's discuss the same and wind up the session, sir. I'll wait. Anything which is there in your mind, please let me know. You attempted the paper previously, you could not score marks, you scored less, anything it can be. Yes, MRP, please tell me what happened. Listening.
Contract Act section 56 impossibility performance. Can you please explain the absolute impossibility of performance and subsequent illegality of performance?
I think you're talking about section number 56, unit number 4, topic number 4. Is it? 56.
Unit number 4, yes, performance of contract.
Performance of contract. The discharge part or which part? There are two parts when the contract is discharged.
In reciprocal of promise from section 51 to 58, in that section 56.
Okay, see, 56 has two parts. The first part says, sir, there can be an impossibility from the very beginning, which we happen to say impossibility ab initio, or you can just call it void ab initio, which is basically the case when we have example agreement with a minor, with or by a minor. It is void ab initio, that is void from the very beginning. It is zero since the very beginning. But in case of supervening or subsequent impossibility, when the contract was entered into, it was valid. Everything was fine. But later upon, due to some change in circumstances or due to change in law, now that particular thing cannot go forward. Let me give you a real life example. Real life example. In Maharashtra, where I belong from, this tobacco is banned. Tobacco is banned. So this political guy, Pawar, I forgot his name, Mr. Pawar. Okay, he basically got cancer when he was at the ruling party in Maharashtra. He basically got cancer. You can Google it afterwards. So what he did is he basically banned this tobacco from the whole of Maharashtra. Now just imagine you and I have done a contract in Maharashtra that I will sell you tobacco, and the contract was valid. Now suddenly this Sharad Pawar, I remember the name now. Now Sharad Pawar comes in and happens to declare that okay, the tobacco is banned. Now as soon as the declaration is out there, I obviously cannot deliver to you the tobacco because it is illegal. So when we entered into the contract, everything was okay, everything was valid. But subsequently, because of change in law, the contract cannot go further. And because it cannot go further, we will say it is a void contract, not agreement, void contract, because there is subsequent or supervening impossibility now because of change in law. Yes, Mr. MRP, are we good now?
Yes, sir. The another thing is absolute impossibility. What is exactly?
It's the same.
difference?
Like you know it already that it just cannot be performed. If you happen to know it even before the contract is entered into, it will be void agreement. For example, I will cross the whole of Indian Ocean. We know it already beforehand that this cannot be done. So hence this will be a void agreement.
And last thing is the difference between novation, recession, and alteration.
Okay, see, this is basically your section number 62 and onwards. 62 is basically novation, which basically says substitution. The old contract will go and the new one will come in. See, remember it like this way. N for novation, N for new. The old one will go and the new one will come. Substitution, like we happen to see this in football. If I happen to talk about the next one, which is basically recession, it is basically going of the previous one, but not coming of any new one. The old one has gone, but new one has not come into picture. What was happening in novation was the old previous contract was gone and the new contract was coming in. In case of recession, the old contract is gone, but the new one does not come in. It is as good as you cancelled a catering contract from the classes. So, and new caterer has not been appointed. So this is rescind, to cancel. Novation is you replaced the previous caterer with a new caterer. This is novation. Going of the previous one, coming of the new one. Recession is just going. If I happen to talk about alteration, these are basically small changes that are basically done in a contract. And we have a difference between, the main difference between novation and alteration is, in novation, the parties to a contract can change. But in alteration, the parties to a contract do not change. And alteration is basically used when we have minor changes. As far as remission is concerned, it is basically compromise. Like I happen to be receiving from you rupees 10 lakhs. But then I tell you, no, okay, what you do is pay me 7 lakhs in full and final settlement. So I have, remitted 3 lakh rupees. I've let go the 3 lakh rupees. And the 10 lakh wala contract has now been only 7 lakhs. So letting go is remission. So summary, novation was the old one going, new one coming. Recession was old one going. That's it. Alteration was the same contract, but some minor changes. And remission is amount which is being let go. Yes, Mr. MRP, are we good now?
Sir. Thank you, sir. I got cleared. And the thing is, whether you solve today's paper or a different paper, sir, mock exam?
See, I have around hundreds of papers, hundreds of pages of papers with me. But what I would suggest to you is, in case you have not done till now, we have mock test paper 2 available on the website of ICAI. Please let me know, are you aware of the same?
Okay, sir. Okay.
See, I'll just show you this. This is my foundation folder. I happen to go to this law bank. This contains 13 attempts of mock test papers, past papers, and revision test papers. If I just go to mock test papers, see, this is the list. I have so many papers. I'm talking about this one, the last one. Mock test paper 2 available on the website of ICAI. A very wonderful paper. You can obviously solve this, and you will find that the questions have been very good. Okay.
Okay, sir. Thank you.
Okay, thank you. Yeah, the next one. I had a message. I'll just see. The message was from Abhijit. I need some preparation strategy for the business law paper, sir. So the time is right now the one in which you cannot learn something new. In case you don't happen to know a particular unit, let's say you have not done unit number 8, bailment and pledge. Let's suppose you have not done so. You can still cover the same by doing 50, 60, 70, any number of questions that you find on the ICAI's website. So if I happen to do 7, 8, 10 questions of bailment and pledge, I happen to basically grasp the topic very well in a very short period of time. Because right now it is not the time that I can go through the whole of the topic, the whole of the unit. No. Right now the topic, the point is, do as many question answers as you can. There are 4 or 5 mock test papers available on the website of ICAI. There are 4 or 5 RTPs available on the website of ICAI, and there are also past papers with solutions available on the website. Just download them and do as much as you can. You will definitely pass. Yes, Abhijit, I hope we are clear now. Still waiting. Anyone else? Any doubt with respect to law? You can ask me. Preparation, section number, presentation, anything it is there, you can ask me. I'll wait maybe 2-3 minutes more. How can we get section number PDF from you, sir? Dhaneshri, I will send it to Sheikh, sir. He is very generous. He'll forward it to you. Okay. Today itself, he'll forward the same to you. Don't worry. Okay, Dhaneshri. Those sections are important also. And those are the numbers that you need to remember also. Next. Come on, fast. You don't have time. Your time is very important. More than mine right now. Do we have any further queries? Or else I'll end the session, obviously, without wasting your further time. No, is it? Okay, in that case, from my end, only thing is left is to send you important list of sections. And yeah, that's it. In case there are any queries, you can just let Sheikh sir know and I'll resolve the same. Okay. So yeah, nice meeting you all from Chennai. Me here from Mumbai signs off. Thank you so much. Bye. All the best, sir. It was wonderful interacting with you and hope you fly high in the exams and we happen to meet in CA Inter. Chalo, tata, bye bye. See you. See you on CA Inter. Okay. Be confident and attempt 100 marks paper. Don't leave the paper blank. Attempt 100 marks worth of paper and you will pass. Chalo, bye 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 bye.